Legal Vidya to give me this opportunity to train law students like you. Once upon a time, even I was a law student, and I know how these training sessions and insights from practicing lawyers are helpful. So, having said that, if everyone has joined, we can start the session. Can everybody see my screen? I'm sharing a presentation. So today we are going to learn about the case analysis. Legal Vidya told me that this is an interactive session. So if you have any questions during the session, you can ask that to me anytime. So let's begin. One second, I'm not able to present now. Let me see why I'm not able to share. Give me a minute.
Ma'am, it was visible. Your presentation was visible.
Yeah, but I'm not able to change the slides.
Oh, all right, ma'am.
Yeah, let me see why. I'm not able to.
Or ma'am, you can select the option of slideshow.
I did
That will
that.
be
I did that, but it's still not happening. So I will go back and change the slides then.
okay.
So let's begin with the case. We'll begin with the basics. What is the case analysis and why you do that in law? I believe in any other field, more than in any other field, doing a case analysis is more important in the field of law because we heavily rely on precedents, case laws. So this is a basic explanation of case analysis in law. So case analysis is a systematic process of breaking down a court decision or legal problem to understand its key elements, the facts, legal issues, the rules, law precedents applied, and court's reasoning. An outcome allowing lawyers to build arguments, find precedents, and apply legal principles to new situations, often using method like IRAC. When I was in law school, in US law school, I was taught this method. when during exams they used to give us a case law and ask apply this method, which is called IRAC. You can say issue, rule, application, conclusion. First, you find out what is the issue, what is the case about, what rules apply to that case. How do you apply that rule to the present case? What is the rule, and how do you apply that particular rule to the present case? And what is the conclusion? Why do we do case analysis? It is essential for students like you to understand how law works and how to think like a lawyer. In legal practice, it helps lawyers to develop strategies, draft briefs, prepare for trial, and advise client. In my current practice, I have so many cases where there is no law, or there are no rules for that particular case, and in for that particular thing we heavily rely on precedents. We go back, we see what the judges have passed recently. Just yesterday I won a case where my case was entire on case decisions. The evidence that I had provided had lots and lots of, like, 30 case decisions from previous judges. So it is very important and the case laws are big, like they are huge in reading. And when you're citing like 30, 40 cases in your brief, you need to know how to quickly read them. You need to know how to quickly understand them. So this rule, IRAC, comes very handy when you know what to read in that particular case. So you read the issue, you understand the rule, you think in your mind whether that rule is applicable to your current case, and then you cite that case. Research. In law field, especially being a lawyer, research is a very important aspect. I was not too good in doing research when I was in law school. For some reason, I used to avoid researching stuff. I used to avoid reading a lot. I like to read, but I didn't think I researched well. But now I see the importance of research, how it is important. So if I have to prepare a brief, I will first and foremost research the cases on it. So how it helps to identify trends in case laws, highlights inconsistencies, and find supporting authority for arguments. So that's why the case analysis is very important. In further slides, we'll do how we can achieve that. And we'll also go through two important cases in Indian law to understand how we can go use this method in the case analysis. Does anyone have a question so far? If not, then I will move to the next slide. One second, I'm just trying to see how. As I explained in my previous slides, what components are there in case analysis? The first is facts. What are the facts? The facts of the case. Um, when I started my law practice in US, and initially I was just asked to do research. I was not given any cases. I was not, I used to not go to the court. They first just trained me to do research. The first thing, when they used to give me a case and ask me to read and analyze the case. When I used to go back to them and tell them that, okay, I'm done, the first thing they asked me, what are the facts of the case? So when you're reading a case, sometimes the case jumps from one issue to the other, from one thing to the other, but you should know how you stick to your facts of the case. So the specific events, circumstances, and the evidence of the case are the facts of the case. The issue. Sometimes the judges during the court session or during a trial go from one legal thing to another, but you should know what your case is about. So the precise legal question that the court needs to handle. For example, one of my client is a rideshare company like Uber and Lyft. If the issue of the case that is before the judge is about an accident, then the issue is an accident case. That's it. If there is a case law where judge has decided other issues as well, but in your current thing, the issue is auto accident. So it is very important what is the issue, and based on that issue, a decision will come up. So the precise legal question that court needs to decide, sometimes it's often yes or no. So in my scenario, I would say that if I'm representing a rideshare company, Uber, there was an auto accident by the driver. Is Uber liable? Yes or no? That is the issue here. Rule. The relevant rules, statutes, legal principles. So is the driver liable? In my case, let's just take my case and understand this case analysis. In my case, uh, there was a driver who was riding an Uber. They met with an accident. The question here is, was Uber liable? So the rule is that Uber is an application company. It is not it is not hiring employees. So there is no employee relation. So that is the rule here. So is Uber liable? That judge will decide. But the rule here is whether the driver was the employee of Uber or not. Application. How the court applies the rule to the specific act. So the rules of employer-employee relationship, the rule of independent contractors, all these rules come into picture. The judge will apply this rule to our issue, the issue being whether Uber is liable in this auto accident case. And then that's the final conclusion. So any questions so far? Okay, I'll share the next slide. Now, how you do the case analysis. As I said, when I started off in the US, I wasn't given any cases. I wasn't given anything concrete to do. All they give me to do research. And that's how it is done here. Like when you are in law school and you're interning somewhere, they usually give you cases, their own cases, and they ask you to do research on that. So how I did it, or how it is done. First, as I told you, sometimes the case decisions, case laws are so big, they go on to pages and pages. First, you need to figure out how to summarize that. You need to read the entire thing and maybe point out, highlight, and make a summary of that case. A summary should be a 2-page or a 1-page summary so that it is easier for you to go on to the next steps. So you, you summarize the case that is given to you. Let's just stick to our case that I gave you the example of Uber. So the whole case is in front of you. There was a driver, he picked up the passenger sat in the car, and then they meet with an accident with another car. This is the summary of the case. Identifying, pinpoint the crucial facts, legal principles, and reasoning. Then you pinpoint the crucial facts. What were the facts? When was the passenger picked up? Was the driver on the app when the passenger was picked up? When the accident occurred, was the driver on the app? What are the principles? For that principles, you need the documents from Uber, that what rules and regulations they have for their driver. Uber is an application. It's an app. It's not a company that hires employees. So that is your reasoning. So you need to review Uber's documents as well as to what they say when such scenario occurs, or what are their rules when such scenario occurs. You read the laws of employment laws, you read independent contractor laws, and then after reviewing these laws, after identifying these laws, you apply them to your current case. And again, the structure to follow this, a very easy method is issue, rule, application, conclusion. When I took the bar exam, we had 6 questions where they prepared a case and they asked us to apply IRAC and answer the questions. So they gave us half an hour, like 30 minutes, to read the question, to read the case, and to apply issue, rule, application, conclusion to the case. So this is very, very important when you are reviewing the case. So first, we identified the issue. The issue was there was an accident by somebody who was driving an Uber. What are the crucial facts? The facts of the case was the driver was on the app. The driver accepted a ride. He picked up a passenger, and they met with an accident with another vehicle. Uh, what the application of laws? What laws do you look into? First, you look into the issue for you is Uber liable? So first you look into, was that driver an employee of Uber? So does the employment law applies here? Second, vicarious liability. If there is an employment law, is there a vicarious liability here? Is Uber liable for driver's activities? Third, what does the Uber contract says? Because when you sign up to drive an Uber, you sign a contract with them. What does that say? Does that show that it is an employer-employee? Does that employment laws are mentioned in that contract? Does Uber say that they will indemnify the driver? And lastly, you follow a structure, you come to a conclusion, and that's how the case analysis of this particular case is done. So in real legal world, we were given such real life cases, and then we were asked to summarize the case, identify the facts, rules, apply those rules, research on those rules, and read the documents of the clients. So I have always represented companies. I've never represented individual. I'm practicing on defense side. So for me, I have to read the company's rules, regulations, their bylaws, their contracts, everything. So that also comes in this analysis. Any questions so far? I thought this was an interactive session, so please ask questions.
Madam, I have a question.
Yes.
In the second slide, if I'm not mistaken, you actually touched on legal research and also my question also links to case analysis. So my question is actually touching on artificial intelligence, AI. So how do you
Mhm.
navigate or how do you incorporate artificial intelligence in case analysis and legal research? So since we are in a technological developed world, so we need to also know how to navigate through. Thank you so much.
Yes, so that's a good question. So yes, AI is now, when I was learning about case analysis, AI wasn't there, but AI is now coming up. And yes, we are taking help of AI to summarize a case. AI, there are so many tools that help us to, if the case is 50 pages, they help us to summarize to 2 pages. Yes, we are doing that. But AI is helping us in summarizing, identifying, but how to apply that rule, how to apply your clients to that particular case is something which you will have to do. So yeah, yes, I would say the work is getting easier and shorter because AI is doing the summary for you, AI is identifying the issues for you, but how that case will be applicable to your case is something that you will have to analyze. Maybe AI will do that for us in the future as well. But for now, we do take help of AI to summarize our cases or to look for the similar cases, um, to help us understand the cases. But how that particular case is applied to our case or our client is something that we have to still do it. Does that answer your question?
Yes, madam. Thank you.
Thank you. Is there any other question? If not, I will go to the next slide. So this is a very, when I was looking up the important cases in India, this came up the first, and I thought, why not take up this case and apply our Iraq formula here. So Kesavan Bharti versus State of Kerala. Uh, let's understand this case. So this case is arguably the most significant in Indian constitution history, defining the limits of parliament power to amend the constitution. Does anyone know this case, and anyone can explain the facts of this case to me? Anyone? Okay, does anyone know this case? Let's start with that. No, nobody? All right, I'll do it. So this case came up as the most important case in the Indian Constitution, and that's why I thought let's explore this case and analyze this case. So the facts of the case were from a challenge to Kerala's government to attempts to acquire land belonging to Montessori land by Swami Kesavanand Bharti under Kerala Land Reforms Act 1963. This challenge required Supreme Court to re-examine the earlier ruling which held that Parliament could amend any part of the Constitution, including fundamental rights. So the facts of the case was, you can read that, and the issue for us was whether the court has the right to amend any part of the Constitution, which includes the fundamental rights of the Constitution. So the central issue, the central question was the extent of Parliament's power to amend Constitution under Article 368. Specifically, could Parliament alter or abolish the Constitution fundamental features? So that was the legal issue, very simple issue, whether the constitute whether the parliament has, not the court, the parliament has the right to alter, abolish the constitution fundamental rights. The judgment was given by a 13 judge bench in a narrow 7-6 decision, ruled that the parliament has the power to amend the constitution, but this power is not unlimited. The court introduced the basic structure doctrine, holding that certain core features of the constitution, such as democracy, federalism, judicial review, and secular character, are fundamental and cannot be altered or destroyed through amendments. This judgment established that judiciary as the final interpreter and protector of the Constitution, preventing potential legislative overreach. The rule of law was also later declared part of the basic structure. So the Parliament does not have the right to amend or alter the Constitution, but judiciary has. So this was an important case where the basic structure doctrine came into the picture, where the rule of law was also later declared as part of the basic structure. So this is how you read the case. You find the facts of the case, the legal issue, the judgment. So here, the legal issue, you had to read the Article 368. You need to know the fundamental rights that is given by the Indian Constitution to its citizens. And then you find the judgment. So if you have any cases where you're looking into how the fundamental rights of citizens are protected, or how each citizen has the right to has fundamental rights, and you can look into the case, you can analyze this case. The judgment given by this case is Parliament cannot alter the fundamental rights or constitutional features. So this is the significance of the case. Another very interesting case I was looking into and I found was, it's not there on my slides because I couldn't include that. I looked at it later, so I didn't include it. But it's Menka Gandhi versus Union of India. Does anybody know about this case? And I found this case very interesting, so I would like to discuss this case with everyone. Anybody? Yes, Akshara has raised her hand. Yes, Akshara.
Hello?
Yes.
Yes, ma'am, it was about seizing of passports. So it's mainly about the right to travel abroad.
Yes, that is correct. Good. Thank
And
you.
also about the Golden Triangle, the interrelation between Article 14, 19, and 21.
Perfect. Thank you so much. Good job. Thank you.
Thank you.
Thank you, Akshara. So Akshara is right. This case is about fundamental, whether the provisions of Article 21, 14, and 19 of Constitution of India are connected with each other or they are mutually exclusive. That's the issue of the case, which Akshara rightly said. So let's see what are the facts of the case. She said, Mrs. Menka Gandhi, who's the petitioner here, was issued a passport under Passport Act of 1967. A notice was issued to petitioner by the regional passport officer to surrender her passport. When the petitioner tried to ask for the reasons, the government of India said declined to her request, stating that it is in the interest of general public. Therefore, she approached the Supreme Court under Article 32 of Constitution. Her main ground in the petition was that the taking away the passport by the passport authority violates the fundamental rights, as Akshara rightly said, 14, 19, and 21 of the Constitution. Um, so first issue, we identified whether the provisions of Article 21, 14, 19 of the Constitution applies to this case. They are mutually exclusive. The second issue is whether the procedure established by law must be tested for reasonably, which in this case was the procedure laid down by the Passport Act of 1967. Can the government take away your passport, confiscate your passport, saying because it's for public interest? Third, whether the right to travel outside the country is a part of Article 21 of the Constitution. Next, what is the scope of the phrase procedure defined by law? Whether a legislative law that snatches away the right to life is reasonable. Whether the challenged order of the regional passport officer in violation of natural justice principles. So we analyzed the facts, we got the issues. Now let's apply the laws. The laws here, the first, where if you are reviewing this case, how would you review it? First, we analyze what were the facts of the case. In one line, I can tell you the fact of the case was that the petitioner's passport was confiscated, cited by the government, citing the reasons of public policy, or what was the reason? In the interest of general public. That was the fact of the case. Second, what were the issues? I just said the issues, whether the government can do that. The right to travel comes under Article 21 of the Constitution. When you get the issues, you need to see what laws you need to read. You will have to read the laws. And I had a question before that how AI is helping. So AI can help us here. Instead of going, I know the lawyers before, they used to have so many books and they used to refer to the books all the time to read the laws. Thanks to the internet, now the AI, we have the laws at tip of our computer. So what law we'll look at first is Passport Act 1967. That explains the variation, impounding, revocation of passport and travel documents, wherein the authority can seize the passport for the reasons provided. We need to review, read the Passport Acts. Was the petitioner provided the reasons, giving the reasons of public safety or for general public interest? Is that a valid reason? Second law we need to read is the Constitution of India, Article 14. Article 14 explains right to equality, equal protection of law within the territory of India. Then we need to look into Article 19 that provides freedom of speech, which is the right to express one's opinion freely without any fear fear of any, you can express your thoughts freely, basically. Freedom of expression includes freedom of press, it covers blogs, websites, etc. Article 21. No person shall be deprived of his life or personal liberty except according to the procedure established by law. The issue that we have to apply to this article, which says that we have the freedom no person should be deprived of his life. So does the freedom to travel include in this? Another principle that is important in this case is principle of natural justice. It means no one shall be commended in unheard, that is, there shall be fairness on the part of deciding authority. Let's go back to our case, whether there was a fairness on the part of the deciding authority to take away petitioner's passport. According to the principle, reasonable opportunity must be given to person before taking any action against him. So if you read this case thoroughly, there were different cases also meant Articles 21, Article 14, Article 19. Let's see what the judge thought about Article 14. The meaning and content of personal liberty in Article 21. Sorry, I meant Article 21. The expression personal liberty in Article 21 of the Constitution is of the widest amplitude, and it covers the variety of rights which go to the Constitution, the personal liberty of man, and some of them have been raised to the status of distinct fundamental rights and given additional protection under Article 19 of the Constitution. It has been held by the court in this is also one other case which you can read is Satwan Singh's case, that personal liberty within the meaning of Article 21 includes within its ambit the right to go abroad, and consequently no person can be deprived of this right except according to the procedure prescribed by law. So Article 21 does include free to travel, you're free to travel, of course, and except if there is the law has a reasoning to it. So it is you can read this case, you can read all these articles of Constitution, the laws, and so we read the facts of the case, we got the issue, we applied the rule application, which is the A in Iraq, and C, the conclusion. Does anybody know conclusion of this case? All right, I'll say. So the conclusion, I'll read out the conclusion. It cannot be said that a good enough reason has been shown to exist for impounding the passport of the petitioner. That's what, when we were doing our analysis, we said that we didn't see any reason. The petitioner has not given the opportunity to prove the case, which comes under Article 21. We just read that. Therefore, the order has been quashed and opposite parties has been directed to give opportunity to the petitioner to show cause against any proposed action on such ground as may be available. In the conclusion, the judges also said fundamental rights provided in the Constitution are neither distinctive in nature nor they are mutually exclusive. Therefore, any law under any statute which deprives the personal liberty of any person must stand the test of one or more of the fundamental rights provided under Article 19 of the Constitution. Thus, reasonableness should be provided in the procedure. And while referring to Article 14, X hypothesis should be tested. Article 21, which I believe was the important one in this case, has been provided a procedure that is established by law and not due to process which conveys the procedure should be those that there are not arbitrary and should not be irrational. The act of the authorities clearly violates one of the basic principles of natural justice known as audi alterum partem, and therefore it is unfair and unjust on the part of the authorities that would, without giving any opportunity to petitioner, they have taken such action. As I said, the reasoning that they gave was for public interest, but no further reasoning was given. The petitioner was not given any chance to ask why her passport has been confiscated, why she cannot travel. Thus, the impunged order impounding the passport of the petitioner were violative of her rights of freedom of speech, expression of, or her right to carry on her profession as a journalist. It would not be saved by Article 19.2 or Article 19.6 because the impounding of passport for an indefinite length of time would clearly constitute an unreasonable restriction. So this restriction was unreasonable. So just an hypothetical scenario, if there are criminal charges against you and if the court thinks you're going to run away, they can confiscate your passport, and that is a reasonable, that is a reason, that is not irrational. But in this case, no reason was given. It was just confiscated. If she would travel, there was no harm to any public. There was no violation of public policy. So this is how you analyze the case. We we saw how we analyzed our own case, but sometimes when you practice, this is all theory, but when you're practicing in real world, you file a petition. There is somebody who's going to oppose your petition. So when your petition is opposed, even in the opposition, they cite the cases. It is very important to read those cases that are cited by the opposite party. You so when you know your case well, when you have analyzed your case well, you can also analyze the cases cited by the opposite party. You have to review that case, and when you in US, when we file a petition and opposition is filed, after the opposition we get a chance to reply to that opposition. So in your reply, you have to oppose to each and every argument of the opposition, including the case laws that they have cited. So you can say the case laws that they cited are irrelevant in our current case because the facts of our case is different than the facts of the case that they cited. So for that reason, you have to read the cases of the opposite parties as well. You have to analyze applying this IRAC rule to the opposite parties' cases as well. So when you know how to apply the rule, when you know how to analyze the case, you can analyze the cases of the opposite party, and that way you can prepare a reply. Last week, I was working on a similar case where, so in US, I don't know if you know, but US has statewide laws. So like in India, you can practice all over India, whereas in US, if you want to practice in New York, you take the New York bar and then you can practice only in New York because laws of each states are different. So last week when I was working on one of my cases, I filed a petition, opposition was filed, I was reviewing the opposition. Opposition had cited a lot of cases. I was reviewing that case. None of the cases were New York cases. One of the case was California case. The other case was Minnesota case. In my opposition, the first, when I was opposing each and every argument made by them, I also made an argument that the cases cited by the respondent are not relevant to our case, our current case, because none of the cases are New York cases. Our main issue, our case is in New York, and the New York law applies to our case. By citing cases of California, Minnesota does not help their case. So that is the reason I could read the case. I could find out that this is not a New York case. It does not apply to the New York law. And that's why this case is, the cases cited by them are irrelevant. Yesterday, we even got the decision for my case, and my petition was granted by the judge. So that's why it is very, very important to analyze your own cases as well as the cases of the opposite party so that you can oppose them. Does anyone have any questions so far?
Sorry, madam. On the case we were discussing, the Menaka Gandhi case, I read the case was some time back, but then I had this other question I just forgot to ask. Does this case actually limit government's power, or it simply requires that the government should be transparent and fair? So which one should we actually pinpoint to say, should you pinpoint to say the case is limiting government's power, or the governments just need to have, I just need to practice transparency and fairness?
So I was not able to hear you properly, but this is what I understood. You're asking what issue should you, when you're reviewing this case, what is the main issue? So yes, does the government has the power to unrightly take away your passport without giving any reasons? No, that is the one issue. So if you, in real life, if you have any case where the client comes to you and says, oh, government has taken so and so, let's just not think of passport, government has taken my land, and does the government have power? No. If there has to be a reasoning to it. So if you did thumbs up, that means that was your question. So yes, there has to be a reasoning. Government does not have a power to Article 21 is above the government. So everybody has the right to personal liberty, except according to the procedure of law. So if I recently read about this film star Shilpa Shetty. I think her passport has been confiscated by the government because they owe a huge debt to somebody and they were trying to flee the country. In that case, the government has the right to take away your passport. But in our current case, which we just analyzed, no reasoning was given by the government. And that answers your question, hopefully. Any other questions? If there are no questions, I will go to my next case. This is the last case I had to discuss, and then I will open up the floor for any questions or anything you have for. So let's look at this case. Let me open that. 1 second. The next case that I read was Shaira Bano versus Union of India. Let's go through this slide and see what this case is about. It is referred to as triple talaq case and a landmark decision addressing general equality and the constitutionality of Islamic practice of talaq bidat, instant triple talaq. The facts of the case. Anybody wants to, it's written here, but anybody wants to say the facts? Anybody knows this case and they want to tell me the facts of the case? If no one, then I'll continue. So the facts of the case was Shaira Bano was divorced by her husband through instant triple talaq. She filed a writ petition in Supreme Court arguing that the practice was unconstitutional and it violated her fundamental rights to equality and non-discrimination. What was the legal issue here? So when I was reading this case, there were a lot of issues. There was the husband was abusing the wife. There was other marital issues as well. But the primary issue that she filed the writ petition was whether the practice of instant talaq was protected under Muslim personal law as an essential religious practice, and if it is violated the fundamental rights guaranteed by the Indian Constitution, specifically Article 14, which says the equality before law, Article 15, that is non-discrimination, Article 21, which we just saw in depth, protection of life and personal liberty. These were the main issues that the case was filed. When I read the case has had a lot of other issues as well, but we had to concentrate only on this issue because she filed the writ petition only on this issue. I would also tell you one real life example where where we had filed a case and the opposition had opposed the case. In their opposition, instead of arguing on the facts of our case, he brought up new facts, was arguing on new things. When the case was heard, when we were before the judge specifically said, this is the issue of this case. The petitioner has filed this case citing these issues. You cannot bring up new issues in your opposition. I agree that maybe new issues that may come up when you are analyzing the case, but you cannot bring that up. So similarly, this case also had a lot of other issues, like the husband was abusive, there were issues in at home or whatever, but that was not she had not filed a case against her husband. Like, she had filed against the husband, but her issue was triple talaq and not the other issues. So that is a very important. Again, we read the facts, we got the issue, how we will apply these laws. What laws are we applying here? Article 14, Article 15, Article 21. These are the three laws we are going to read and apply them. So what was the judgment? A 5-judge constitutional bench in a 3-2 majority verdict declared that the practice of instant triple talaq was unconstitutional, arbitrary, and illegal. The court held that the practice was not an essential part of Islam and infringed upon the dignity and rights of Muslim women. So this case, I brought up this case because I read online that this was a significant case for the protection of rights on marriage, Muslim women. So the judgment was a major victory for women's rights in India, leading to the enactment of the Muslim Women Protection of Rights of Marriage Act 2019, which criminalized the practice of instant triple talaq. So this was one of the interesting cases where the issues were, we read the constitutional articles, the rights guaranteed by the Indian Constitution, and how our plaintiff or petitioner won this case because the judge said that it violates her fundamental rights guaranteed by the government, which is Article 14, 15, and 21. I have one more slide explaining more about this case, but if you guys have anything, please ask. Any questions on this case or any case or anything? While I bring up my next slide, if you guys think of any questions, please ask. This is my last slide explaining about the case that we just discussed. Shaira Bano versus Union of India. It's a recent 2017 case, was a landmark in Indian Supreme Court where 3-2 majority declared the practice of triple talaq unconstitutional, ruling it arbitrary and violation of Muslim women's fundamental rights to equality. Article 14, right to life, Article 21. The judgment stemming from Shaira Banu being divorced by her husband through this practice called for Parliament to legislate, leading to Muslim Women Protection of Marriage Act 2019, which criminalized triple talaq and granted wives maintenance. During this, in my initial slides, I had explained what are the key aspects of analysis. So this is a short analysis of how we analyze the case and how we apply the rules that we learned to analyze the case. So the key aspects of the case is the petitioner. First, we need to know what is the issue here. The issue here is that the petitioner challenged the triple talaq, where a husband could divorce his wife instantly by uttering talaq 3 times, often via letter, text, whatever. That was the issue. She filed a case citing this issue. Her case is this. She is against triple talaq. Constitutional challenge. Bano argued that this practice violated her fundamental rights, including equality, life, and personal liberty. The ruling, we all know what was the ruling. The outcome, the court struck down the practice and directed Parliament to act, resulting in Muslim Women Protection of Rights Marriage Act 2019, which made triple talaq a criminal offense with imprisonment and provided for maintenance. And we also saw the significance of this case. So this is how, in conclusion, I would say that it is very, sometimes when you are reading a case, and it used to happen to me a lot when I used to read some case, I used to just get lost in the case because the cases were like 50 pages. You're reading them, what you read in the beginning, you don't know. There are various cases cited in that case, so you go to that case has different facts. So sometimes, and it is very easy to get lost into the case and then you forget what you were actually reading that case for was. So when you keep this IRAC formula in mind, issue, rule, application, conclusion, it becomes easy. You just have to keep your issue, your case issue in mind. You have to you should know what rules are there for that issue. Like in the current case, if you see, what was the issue? The issue was triple talaq. What is the rule for that issue? Is that constitutional? Yes, no. You need to read the Constitution. You need to read the articles of the Constitution. Then again, you narrow down which articles will you apply, which constitutional articles will you apply to this one, to this particular case. So Article 14 and Article 21. And then you come to a conclusion whether the triple talaq was constitutional or not, yes or no. So this is a simple method of analyzing a case so that you don't get lost when you're reading pages and pages of cases. I'll open up the floor for any questions now. Does anyone have any questions? If there are no questions, when I was reviewing this Shaira Banu case, I found a good case analysis of this case, and I would like to share that with you if there are no questions. And in that analysis, they have also shared the arguments of the respondent. So we can go over that if there are no questions. If there are any questions, I'm happy to answer that now. So as I said, while I was reviewing, this doesn't go up and down. Hold on, I will just share what I was reviewing about this case. So here you can see the argument for the petitioner. Amit Chadda, an advocate from the petitioner's side, stated that triple talaq was never recognized by Muslim personal law and was completely contradicted to the principles given under the Quran. Hence, triple talaq has no legal value whatsoever. He also stated that since triple talaq is violative of Article 14 and 15 of Indian Constitution, it should not be valid and must be struck down. Salman Khurshid, another advocate for petitioner's rights, stated that triple talaq is followed by a period of 3 months where the couple try to reconcile. If, however, there is no reconciliation during this period, then the third time the husband says talaq, the divorce would be complete. He also argued that most Muslim communities do not even consider triple talaq as to be a valid one. Therefore, it must be considered void. These were the arguments of the petitioner. Now let's see the arguments of the respondent. Kapil Sabil, when I was in India, he was a practicing lawyer, so I think I know him. An advocate from the respondent side made an advent stating that judicial review is not acceptable because Muslim marriage is private contract. So he brought contract law also into the picture. So when you're reviewing, as I said, when you review the opposition arguments, you see what arguments they have made. So you have to, if they have come up with new laws, if they have come up with new citing cases, you have to go through them. He again brought up a private contract. He also argued that personal laws are not included in Article 13. He also stated that triple talaq is not discriminatory towards Muslim women as they seek remedies as per Special Marriage Act, asking for a higher mahr amount. So this is their argument that this comes under Special Marriage Act. There is a private contract, and it is not included. Since it's a private contract, it's not included in Article 13. There is also critical analysis made here. Let's read that. Validity of instant triple talaq. Triple talaq is a way, we know what is that. The analysis of this is how this, however, works contradictory to Quranic principles, as according to the Quran, the marriage is supposed to be unbounded in time. So the analysis of this case is whether the Quran says that and whether triple talaq is arbitrary in nature, and it is arbitrary in nature. There have been countless instances where women have been divorced through the method of triple talaq via Skype, Facebook. That's what the analysis says. What does it say next? So Article 25 of the Indian Constitution provides for the freedom to profess, practice, and propagate religion of all citizens of India. It clearly states that religious activities that are essential to that particular region are protected under it. So even if the respondents argued that it's a private contract, it is not, because it clearly states, Article 25 clearly states that religious activities that are essential to that particular religions are protected under it and are not secular activities related to that religion. Even though All India Muslim Personal Law Board argues that triple talaq is essential custom of Islam, organizations such as Bharatiya Muslim Mahila have stated that it is not. So this is a critical analysis of the case, that why the private contract, as stated by the respondent. The respondent states that the constitutional right does not apply here because Muslim personal law applies here. Why it does not apply is noted in Article 25. It should also be noted that Article 25 it's not an absolute right. It is subjected to certain restrictions such as public order, morality, and health. So the right to practice triple talaq custom is against public morality and violence the fundamental rights to non-discrimination, equality, and personal liberty as given under Article 14, 15, and 21 of the Indian Constitution. So when you analyze the case, it makes sense that the triple talaq, even that is protected by the Indian Constitution, and it is not a private contract, and it is not under Muslim law, personal Muslim law. So I can share this analysis that is done with Legal Vidhiya, and they can share with everybody. It's a very good read. Everybody should read this to understand how to analyze the case. If there is any further questions, I'm happy to answer. No questions? Any questions as to the practical law or any questions as to real practice? I'm happy to answer that as well. Anybody from Legal Vidya here? If they have no question, I had kept 15 minutes for questions, but I think nobody has questions here. You can also type your questions in the chat, and I can still answer them. If there are no questions, we can sign off. Legal Vidya.
Shall I conclude, ma'am?
Yeah, because there are no questions. Nobody has questions. Okay, someone has. While drafting a case analysis, do we have to mention the case citations from the main judgment? when you are doing your own analysis, you can review the cases, you can research the cases. But yes, when you're writing a brief, you're writing a draft brief, you have to mention the case citations. Yes, the whole citation has to be mentioned if when that brief is to be submitted to the court. So when you're doing your internal when you're doing your internal review of the case, you can just read the cases. But when you are drafting a brief, the whole citation has to be mentioned of all the cases that you cite. Thank you. Next question, what are all the sources we can consider while case analysis? My next session is on legal research. So in that I can mention the sources, but there are a lot of sources available online where you can research the cases. Back in the day, the lawyers used to refer to books. We have now internet, we have AI, so it is easier to look for the cases. And my next session is on legal research, where I'm going to explain how to research the cases. But yeah, there are sources online where you can research the cases. Is there any other questions? You can write in the chat and I can answer them. And if there are no questions, we can end the session.
Thank you to all the participants for joining us today, and a special thank you to Kirna Modi ma'am for her invaluable insights and for concluding the session so gracefully. Wishing everyone a wonderful evening ahead.
Thank you, everyone. Thank you for joining.
Thank you, ma'am.
Thank you.